the respondent contends that both applicants do not have fixed places aboard because they did not provide land titles or tenant agreements to show the fixed places of aboard, and therefore they may not be located or held accountable if they jumped bail. Counsel for the applicant submitted that both first and second applicants provided evidence in support by each applicant about their respective fixed places of abode. In the case of the first applicant, he provided 2 locations at Buyinja LC1, Wampeo, Ward, Kasanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, Southern Division, Rukonjiri Municipality in Rukonjiri District. And in the case of the second applicant, the location is Isigula Village, Cell, Mutundwe Ward, Gombola Savagabo, Makindye Wakiso District, also within the jurisdiction of this Honorable Court. Regarding pending charges, counsel for the applicant submitted that the second applicant has no pending charges against him, and that the first applicant having a pending charge at Uganda Road Court cannot be used to dismiss the second applicant's application as submitted by the respondent. Counsel further stated that the respondent in fact, the first applicant has been put on his defense or found guilty, that he does not cease to enjoy the constitutional presumption of innocence because he has a pending case. Counsel for the applicant stated that the fact that the first applicant was charged with current offense while on bail in respect of the Uganda cannot be used against him, and it is the same state that charged him that is now using those charges to argue that he should not be granted bail, alleging he reoffended while on bail. Regarding the possibility of interfering with witnesses and investigations, counsel for the applicants submitted that in Panju versus Ara 1973, Volume 1, East African Road Courts at page 282, it was held that the allegation of interference with witnesses must be substantiated and that such substantiation is not difficult to show. Counsel submitted that there is no evidence that there has been placed before this court by the respondent to show that the alleged strong likelihood of interference with the witnesses or investigations. Counsel prayed that this Honorable Court finds no likelihood of of the respondent on this point. While submitting in respect of applicant's age, counsel submitted that the courts can, and in this case, should take judicial notice that prisons are not holiday destinations. That the fact that there are harsh conditions on remand has been taken note of, including in cases cited by the respondent, such as the case, Augustine case. In respect of possibility of absconding, it was submitted for the first applicant and second applicant that since the arguments of the respondent seem to focus more on the first applicant, then the argument should not prejudice the second applicant, and that the evidence of the first applicant's mastery of the game, presumably fleeing from Uganda, is not supported by any evidence. Counsel further submitted that the first applicant has demonstrated that in the past, when released on bail, and he required to travel outside the prison, he only undertook it with permission of the court. He would go out of the country and return. Regarding the sureties, it was argued for the applicants that the sureties presented were advised about their role of by the Honorable Court, and none of them protested or said that they were unable to perform their roles. In Kawanguzi Sereko David versus Uganda, criminal miscellaneous application number 426 of 2020, 2023, the court held as follows. It is